the inhabitants. The Supreme Court of California, in the opinion pronouncing the judgment in this case, said, "The Board of Supervisors, under the several statutes conferring authority upon them, has the power to prohibit or regulate all occupations which are against good morals, contrary to public order and decency, or dangerous to the public safety. Clothes washing is certainly not opposed to good morals or subversive of public order or decency, but when conducted in given localities, it may be highly dangerous to the public safety. Of this fact the supervisors are made the judges, and having taken action in the premises, we do not find that they have prohibited the establishment of laundries, but they have, as they well might do, regulated the places at which they should be established, the character of the buildings in which they are to be maintained, etc. The process of washing is not prohibited by thus regulating the places at which and the surroundings by which it must be exercised." The Order number 1569 and Section 68 of Order number 1587 are not in contravention of common right, or unjust, unequal, partial, or oppressive in such sense as authorizes us in this proceeding to pronounce them invalid. After answering the position taken in behalf of the petitioner that the ordinances in question had been repealed, the Court adds, "We have not deemed it necessary to discuss the question in the light of supposed infringement of petitioner's rights under the Constitution of the United States, for the reason that we think the principles upon which contention on that head can be based have in effect been set at rest by the cases of Barbier v. Connolly and Soon-Hing v. Crowley. The writ was accordingly discharged and the prisoner remanded." In the other case, the appellant, Wo Lee, petitioned for his discharge from an alleged illegal imprisonment upon a state of facts shown upon the record precisely similar to that in the case of Yick Wo. In disposing of the application, the learned Circuit Judge Sawyer, in his opinion, after quoting the ordinance in question, proceeded at length as follows: "Thus, in a territory some 10 miles wide by 15 or more miles long, much of it still occupied as mere farming and pasturage lands, and much of it unoccupied sandbanks, in many places without a building within a quarter or half a mile of each other, including the isolated and almost wholly unoccupied Goat Island, the right to carry on this, when properly guarded, harmless and necessary occupation in a wooden building is not made to depend upon any prescribed conditions giving a right to anybody complying with them, but upon the consent or arbitrary will of the Board of Supervisors. In 3/4 of the territory covered by the ordinance, there is no more need of prohibiting or regulating laundries than if they were located in any portion of the farming regions of the state. Hitherto, the regulation of laundries has been limited to the thickly settled portions of the city. Why this unnecessary extension of the limits effected, if not designed to prevent the establishment of laundries, after compulsory removal from their present locations, within practicable reach of the customers or their proprietors? And the uncontradicted petition shows that all Chinese applications are in fact denied, and those of Caucasians granted, thus in fact making the discriminations in the administration of the ordinance which its terms permit. The fact that the right to give consent is reserved in the ordinance shows that carrying on the laundry business in wooden buildings is not deemed of itself necessarily dangerous. It must be apparent to every well-informed mind that a fire, properly guarded for laundry purposes in a wooden building, is just as necessary and no more dangerous than a fire for cooking purposes or for warming a house. If the ordinance under consideration is valid, then the Board of Supervisors can pass a valid ordinance preventing the maintenance in a wooden building of a cooking stove, heating apparatus, or a restaurant within the boundaries of the city and county of San Francisco, without the consent of that body, arbitrarily giving or withheld, as their prejudices or other motives may dictate. If it is competent for the Board of Supervisors to pass a valid ordinance prohibiting the inhabitants of San Francisco from following any ordinary, proper, and necessary calling, within the limits of the city and county, except at its arbitrary and unregulated discretion and special consent, and it can do so if this ordinance is valid, then it seems to us that there has been a wide departure from the principles that have heretofore been supposed to guard and protect the rights, property, and liberties of the American people. And if by an ordinance, general in its terms and form, like the one in question, by reserving an arbitrary discretion in the enacting body to grant or deny permission to engage in a proper and necessary calling, a discrimination against any class can be made in its execution, thereby evading and in effect nullifying the provision of the national Constitution, then the insertion of provisions to guard the rights of every class and person in that instrument was a vain and futile act. The effect of the execution of this ordinance in the manner indicated in the record would seem to be necessarily to close up the many Chinese laundries now existing, or compel their owners to pull down their present buildings and reconstruct of brick or stone, or to drive them outside the city and county of San Francisco to the adjoining counties, beyond the convenient reach of the customers, either of which results would be little short of absolute confiscation of the large amount of property shown to be now and to have been for a long time invested in these occupations. If this would not be depriving such parties of their property without due process of law, it would be difficult to say what would effect that prohibited result. The necessary tendency, if not the specific purpose, of this ordinance and of enforcing it in the manner indicated in the record is to drive out of business all the numerous small laundries, especially those owned by Chinese, and give a monopoly of the business to the large institutions established and carried on by means of large associated Caucasian capital. If the facts appearing on the face of the ordinance, on the petition and return, and admitted in the case, and shown by the notorious public and municipal history of the times, indicate a purpose to drive out the Chinese laundrymen, and not merely to regulate the business for the public safety, does it not disclose a case of violation of the provisions of the 14th Amendment to the National Constitution and of the treaty between the United States and China in more than one particular? If this means prohibition of the occupation and a destruction of the business and property of the Chinese laundrymen in San Francisco, as it seems to us this must be the effect of executing the ordinance, and not merely the proper regulation of the business, then there is discrimination and a violation of other highly important rights secured by the 14th Amendment and the treaty. That it does mean prohibition as to the Chinese, it seems to us must be apparent to every citizen of San Francisco who has been here long enough to be familiar with the course of an active and aggressive branch of public opinion and of public notorious events. Can a court be blind to what must be necessarily known to every intelligent person in the state? But, in deference to the decision of the Supreme Court of California in the case of Yick, and contrary to his own opinion as thus expressed, the circuit judge discharged the writ and remanded the prisoner. Mr. Justice Matthews delivered the opinion of the court. In the case of the petitioner, brought here by writ of error to the Supreme Court of California, our jurisdiction is limited to the question whether the plaintiff in error has been denied a right in violation of the Constitution, laws, or treaties of the United States. The question whether his imprisonment is illegal under the Constitution and laws of the state is not open to us, and although that question might have been considered in the circuit court in the application made to it, and by this court on appeal from its order, yet judicial propriety is best consulted by accepting the judgment of the state court upon the points involved in that inquiry. That, however, does not preclude this court from putting upon the ordinances of the supervisors of the county and city of San Francisco an independent construction for the determination of the question whether the proceedings under these ordinances and in enforcement of them are in conflict with the Constitution and laws of the United States necessarily involves the meaning of the ordinances, which for that purpose we are required to ascertain and adjudge. We are consequently constrained at the outset to differ from the Supreme Court of California upon the real meaning of the ordinances in question. That court considered these ordinances as